international viewers and our listeners on the new U975 FM Multicultural Radio, all of our viewers on Synergy TV, on the Caribbean Showtime Television in Canada, a very warm welcome to another edition of the program Conversations with Zelisa, where we continue to inform, educate, empower and answer those unanswered questions. I am Zelisa Singh Rupani, humbly inviting you to sit back, relax, enjoy, get your pen, get your paper, get your phone, so you could take notes and, telephone contact numbers that will be very helpful for you and your loved ones. Directing this morning and in Master Control, Akua George, we'd like to wish each and every one of you a wonderful day today. It's the middle of the work week, but you know what? It's the 1st of February, 2023. January gone, gone, never to come again. That's how important time is. So let me remind you, don't waste your time. Don't procrastinate. Do what you've got to do today. And if you're celebrating a birthday, happy birthday. If it's your anniversary, happy anniversary to you and yours, that someone special. Let's quickly go to our quote for today, coming to us with the kind compliments of ZMB Communications Limited. And it says, we cannot solve our problems with the same level of thinking that created them. Oh, I love this, Akua, because it's the truth. We cannot solve our problems with the same level of thinking that created them. You really have to challenge yourself and change your perspective on how you think and how to solve problems and get to the root of it and get rid of it. I love it. It came to us with the kind compliments of ZMB Communications Limited. Let's say good morning and a very, very warm welcome going out to, she's not a stranger, she's very much part of the programming, attorney at law, a walking institution. She's a force to be reckoned with. Sajina, Kadir.
Good morning, Zelisa, and to everyone listening and viewing. Good morning as well.
Always nice to have you.
Always a pleasure being here.
I get calls every day asking, so it's always a delight to sit with you and be able to really empower the public, both those are listening and are viewing.
That's the correct word you use there, and even of the Community Justice Clinic, we were chatting of a lot of the persons who would have come to the clinic from viewing or listening to this program were really, grateful for the message being out there so that they could know about the free legal clinic. So we continue, as team lead for the attorneys, we continue to be grateful for you in that capacity with that initiative as well.
I am forever grateful for the initiative that you guys have taken and now partnering in terms of getting the information. It means we can help more and we could do more.
That's right.
And that's our goal, yeah?
Yes.
So today we are going to continue the series that we started, and we are going to be talking about wills. We're going to be talking about the power of attorney, and I think a lot of people kind of get that confused.
That's right.
So we're first going to define that.
Yes.
And then we're going to continue our conversation, open up the telephone line, give you the opportunity to call in or perhaps send in your WhatsApp messages, whatever you feel comfortable with. But this program has been designed to really help you understand the law and of course make better decisions and choices.
That's right.
Knowledge is
yes, it definitely is. The will, to understand what a will is, as you were saying, it's clear, it's better to define it. A will is a legal instrument, a document that a person makes whilst they're alive to determine who should get their assets upon their passing.
Right.
And in order to have this effected when you pass away, you have to have somebody responsible for doing the duties of the will to probate that will. So you call that person an executor if that person is male, and an executrix if the person is female. So your will must state who is that executor or executrix and what assets you have and who is to get it upon your passing.
Now, a will is something that's extremely sensitive, and we are talking about it very casually.
Yes.
And the reason we are doing that is because a lot of people are very hesitant, or they kind of neglect to understand the importance, really the depth and importance of a will.
Yes.
But it's inevitable that we are going to pass one day.
Yes.
We work hard. It's inevitable. We can't change
people think wills are for people who are older to make it, but I mean, you can make a will anytime.
You live.
That's the only sure thing, right?
Yeah, that you're sure, exactly.
Yeah,
you're correct,
death is the only sure
that you're
thing.
going to pass, right? And it's a sad thing sometimes to think about. Like, the truth is, sometimes I think about, I mean, my parents are older now, and you can't, sometimes you think about it and I get emotional about how you're going to deal, especially when you find out about people passing and things like that. And you're very correct. You said something very important. We often think that we wait till we're older and then we want to do it.
Yes.
But we should take responsibility and understand that nothing is promised, tomorrow is not promised.
That's
and
right.
you really need to put, if you love your children or your spouses or your family, you really have to.
And you want to put things in place, go out and make a will. And I said openly on this program, I would have also made a will during my first COVID, because you just never know.
You never know.
That's the reality of life, you know. And it's important to make that will so all your assets, someone will know, that executor or executrix charged with that responsibility upon your passing will know how to give off your assets how you truly desire.
Exactly, because the thing is, you've worked hard all of your life. You deserve to, whom you choose, and that's another thing.
Right.
You have to understand it's your choice at the end of the day, and don't be don't be manipulated in any way.
Yes.
Do what you think is right and what you want to do.
Because
that is important.
If you don't make the will, then the regular law takes effect. So half goes to the surviving spouse, half to the children, equal shares. And I've seen matters, and there's case law set from Stone Age, where persons just opted not to leave it to their family, but opted to give it to their maid, their housekeeper, their gardener, people who took care of them.
Because sometimes these are the people that genuinely care about them and take care of them.
Exactly. You know, so it's important to make that will. And then it's very important, as you said at the start of the program, to understand the difference between making a will and doing a power of attorney. Because oftentimes persons will come to attorneys' offices and say they want to get a power of attorney to sort out somebody's assets, right? But a will takes effect only when a person passes away.
Right.
But a power of attorney, if we had to define it, a power of attorney is a legal instrument, so a legal document that empowers a specified person to do the duties or conduct your business affairs or your financial affairs.
So they actually will be responsible for executing your wishes
whilst you are alive. Exactly. That's the big difference.
The will, it takes place when you pass and move on, and then of course while you're alive.
Yes.
So let's say you're sick, you're not well, and you identify somebody. Okay, great. Excellent.
So the power of attorney ends when the person passes away. And if the person passes away and that power of attorney no longer exists because it dies upon that person's death, then you check to see if the person has a will to see what they had wanted to do with their assets. But a person who is granted the power of attorney, so if you gave me the power of attorney to conduct your affairs for you, I could only do that whilst you're alive then. And if you pass away, I'll knock on that, Lord forbid. At the end of the day, the power of attorney dies upon the person who granted it, upon their passing.
Okay, understood. And I think now we've identified that. I think a lot of people were still not too sure.
Yes.
And now you understand the difference between a will and then the power of attorney.
Yes.
And the importance, again, we're going to continue to elaborate and try for you to understand that it is important to have a will to put things in place when you pass.
Yes. So some persons may be wondering, so what does a power of attorney contain? Right? So a power of attorney gives the person who the power is granted to that power to conduct financial and business affairs. But it does not give the power to make medical decisions for somebody. So it's their general affairs or specific. So a power of attorney could be general to conduct any financial or business affairs with regard to real or personal property, right?
So can you give me an example? Because you said something there that's important, and that is cannot make decisions based on medical.
Right.
So can you give me a case? Or
of course, when a power of attorney, So if somebody lives out of the jurisdiction, and it's not prudent or practical for them to come to Trinidad to conduct their business affairs because it's not cost effective. They're not going to come here often. So they do a power of attorney, let's just say in Harry's name, because Harry, they trust Harry. They know Harry will conduct their wishes. So a power of attorney is done so Harry can now go to the bank and do transactions for on behalf of that person who is abroad. Right. Another example, if the person is in Trinidad, let's just say I'm here, I'm working, I'm tied up with commitments, so I can't go up and down to the bank, or I can't go up and down to the licensing office to do something that needs to get done. I grant the power, I do a power of attorney in the name of X, for X to conduct my business or financial affairs on my behalf, though I'm right here. If for some reason the person is sick, but it does not affect the soundness of their mind, so that their knee has an injury and they don't want to take that up and down, but they're very capable of making a decision, they could grant a power of attorney to person X, so that they don't have the hassle of going up and down. But when we say a power of attorney cannot give somebody the power to make a medical decision, only a court order could do that. So therefore, if somebody is not well, the only person who could, if somebody wants to act to make medical decisions on their behalf, if they are not of sound mind or not fully aware of things or suffer dementia or something like that, a power of attorney is not the appropriate document to do. Only the order of a court applying to a judge of the high court to be their guardian then, to carry out or act in their best interest medically, only a court order will work for that. So a power of attorney, the only medical twister power of attorney is if somebody has a physical injury. It has nothing to do with their soundness of mind. So if they are not of sound mind, you cannot do a power of attorney just for a matter of convenience, because that is not what a power of attorney constitutes. A power of attorney is only to conduct the financial or business affairs with regard to real or personal property of the individual granting it.
I would jump in here immediately and suggest that when you do decide, or if you do decide to assign a power of attorney to someone, then you make sure that this is someone that you really trust.
Wow, that's such an important point that you make there, because you have to, just like how with a will, you put in it in the fate, all your fate goes into that executor or executrix to conduct that responsibility for your desire. Same for a power of attorney, Zelisa. You have to, as you say, make sure it's somebody you trust, because a lot of times you will see where a power of attorney is granted and, you know, the person gets a little freeway to do what they take out money and stuff. And it could become a problem between the person who granted the power and the person who has the power, who's abusing it. You know, and in a situation like that, the only real way to stop that person from abusing it is to revoke the power of attorney. And the only way
that can be done.
Yes, but it's by a formal document. So a power of attorney, when it's executed, must be registered at the legal affairs, right? And in order for it to be void now, it must be revoked formally and registered legal affairs. So these things are processed, right? And it takes time. So what you say is correct. You have to be able to trust that person.
Good. Trust is important.
Definitely.
This is a program, Conversations with Zelisa. Of course, to all of our viewers on Synergy TV, all of our viewers on the Caribbean Showtime television in Canada, and of course all of our listeners on the new U975 FM Multicultural Radio. Thank you so much for choosing us in conversation with, you know, this lady who is simply awesome and quite competent. And I'm speaking of attorney at law Sajina Kadir. We're going to go to a short break, take in some important messages. When we return, we're going to continue our conversation, but I'm going to open up the telephone line and give you the opportunity to call in with your questions, your concerns, whatever problems you're facing with regards to our topic. Or if you want to send in your WhatsApp messages, you can do that. But again, a gentle reminder, when you're calling in, or please remember, whether it's via television or radio, a gentle reminder, please take the volume of your television or radio down. First, take the volume down, then call, speak into the phone so we can hear exactly what you're saying. And this way she would be able to answer any questions or concerns you may have, all right? So let's go to these messages.
Super quality supermarket. Best quality and great prices. Get your fresh fruits, vegetables and meats. It's a one-stop shop for the most affordable groceries, baby items, kitchen supplies, bathroom accessories, car care supplies, pet food, toys and lots more, all at Super Quality Supermarket. Wide aisles, fully air-conditioned and secured parking. 3 locations nationwide: Couva Car Park, Couva, 98 Endeavour Road, Chagonas, and 47 Tissue Drive, Trincity. Super Quality Supermarket.
The carnival season is upon us. Chutney Soca News, in collaboration with ZMB Communications Limited, is bringing the fun and excitement to you. We are throwing a studio party. Get ready for CSN Live. Live interviews, a live audience, live entertainment, and so much more. This and every Friday from 8 p.m. to 9 p.m. Broadcasting live on Facebook on Chutney Soca News TT, U97.5 FM, Multicultural Radio, and ZMB Communications. You can also look out for the rebroadcast on YouTube on ZMB Communications Limited and Chutney Soca News every Monday at 8 p.m.
Visit Agri Savers Limited, number 19 Orange Grove Trace, St. Augustine, for all your agriculture, livestock, pet, agri-equipment, hydroponics, cannabis, fishing tackle supplies, and much more. Open Monday to Friday 7 a.m. to 5 p.m. and Saturdays 7 a.m. to 3 p.m. Contact 473-6074, 663-1094. Follow us on Facebook and Instagram.
The Untold Truth, every Friday at 6 p.m. The journey has just begun with Master Eric. Zelisa. A new kind of podcast getting to the root of hidden knowledge. You can join us on Facebook, Conversations with Zelisa, TT, and YouTube, Master Eric. Your journey has just begun.
Passage to Asia. Ultra all-inclusive. Carnival Kisses. Sunday, 5th February 2023. St. Andrews Golf Course, Boca, Maravao. Get your tickets at Passage to Asia. Wings, Tuna Puna, Extra Food, Riverline, Price Plaza, MS Food City, Dede, Westbees, Diego Martin, Richards, West Mall, Dave Sebelak Hardware, Pinal, SC Persad Hardware, Maravella, Brand Tech, Londonville, Lazy Lizard, Rodney Road. Call 672-2701, 742-4309, 685-8697, and 465-7322. Passage to Asia. Carnival Kisses.
Welcome back to Conversations with Zelisa, in conversation with attorney at law Sajina Kadir, and today she's talking to us about wills and of course the power of attorney. So welcome back.
Thank you.
So we are now going to open up the telephone line. Again, a gentle reminder, when you do call, if you may have any questions, any concerns, please take the volume down on your television and your radio. Before you call, then speak into the phone, or you can send your WhatsApp messages. So 3847142, 3847142, questions, concerns, comments, feel free to call in or feel free to send us a WhatsApp message with regards to your concerns. So we're continuing. If you have some complications or difficulties with a will, with power of attorney, anything to that effect, you can call in and she'll be more than happy to advise you accordingly.
So I want persons to understand, just like how we explained, a will must be duly executed so that you have witnesses over the age of 18 who are not related to the beneficiaries. Same for a power of attorney. A power of attorney must be prepared by a legal mind,
good,
likely not an
like
attorney.
Yourself. Okay.
Yes, and it must be executed so that the person granting the power signs, but that there is one independent witness over the age of 18, usually it's a secretary, to witness the will. And then that witness, an affidavit is done to show that all parties, one of the witnesses, whether the attorney or the secretary, will do an affidavit that must be sworn to before a commissioner of affidavits or a justice of the peace, stating that all parties were present in each other's presence and saw this occurring, and that authenticates the validity of a power of attorney, and it's considered duly executed in law.
Great. To that caller who is calling, and I humbly apologize, I did not want to break the trend of what Linda Council was saying. So feel free to call 3847-142, 3847-142, or you can send in your messages. I will read it to her. All right, so to that caller, again, I humbly apologize, and you can feel free to call us.
So when there is a power of attorney, as I was stating earlier, it is to manage financial and business affairs, right? I see a caller. Yes.
May I? Thank you. Good morning. Welcome.
Hello, good morning, Miss Alicia.
Good morning. Can I get some volume, please, Director? Thank you.
Miss Alicia?
Yes, dear.
This was a really serious matter with Miss Nightfall Coolman. Look how many years these gentlemen them was in the jail. After all these years, what they have them inside, they're doing in the jail. If there is not convicted anything like Whitman Coolman, what they have them there, and they say they is not guilty.
Right. Well, you know, we're not really talking about that, but since you raised it, I will still ask counsel to address. And I'll tell you something.
But at the same time,
and let me say this. I was fortunate enough to have met Miss Naipaul when she was alive. She was a very soft, she had a very gentle soul, a very religious lady. I would have met her in the confinements of a satsang. And I met her as a very humble person, and I was really very saddened, and still very is, that there is no closure.
Yes.
And still looking. So I mean, we're not really talking about that today, but it seems to be of concern.
Yeah, but at the same time, it has, after they given this all amount of money, it has things to do with that money. Public servants need their money. The road one fixing, people's house getting burned down. Look up till last night they showing you one get burned down.
I can respond.
It has so many things to do, and they say the country don't have money.
Right. And money is being wasted. I truly understand. Okay, darling, thank you so much for your comments. And it seems to be of concern, not just to you, but many people. Council, would you like to add to that?
Even though it's a bit off the topic, I feel obliged to just explain that, you know, whilst the interest of justice must be served, due process must also not be ignored. And if there are persons that are imprisoned currently pending the court system, there's a presumption in law that the person is innocent until proven guilty. So the natural course has to take effect.
Yeah. A quick question. Can a power of attorney create a will on a person's behalf?
No.
No. The answer is no. All right.
Outright no.
Welcome. Hello.
Good morning.
Good morning.
Good morning. I would like to find out something.
Sure.
If someone is put as an executor of a will and that person dies, what power does that person have?
The person who is
put as the executor passes away.
That's a good question, you know, a very good. Thank you. Can you listen off air, please?
So there would not be a named person who the testator trusts to duly carry out the responsibilities of the will.
Right.
There remains named beneficiaries, and the beneficiaries will have to make an application, file an application before the court to appoint X person to whom they believe will conduct the affairs, whether one of themselves or an independent person who they believe will be responsible to carry out the wishes and do the needful to regularize whatever the assets are in the names of the lawful beneficiaries.
This is another good question that's coming in. Good morning, Ms. Zelisa. Could the attorney say what happens if a will is not made? For example, what happens with your money in the bank?
Right.
This is a great question.
Right. So, a more detailed explanation would have been on our previous series on letters of administration, which is on your Facebook page.
Yes.
But I can say that if there is no will and the person is married, half of what exists in the bank account will go to the surviving spouse and the remaining half to children in equal shares, but only when an application for letters of administration is actually filed, because regular law takes effect in the absence of a will.
Right? Good. Welcome to the program.
Sorry.
That's all right. Hello.
Hi there, good morning.
Good morning.
Yes, I would like to find out something.
Mm-hmm.
If when my dad made his will,
Yeah.
he had my name on it, and
Right.
he passed away 15 years ago.
Right.
And my brothers had the power of attorney, right?
Mm-hmm.
Would they be able? They remove my name from the will. Is that possible?
No.
That's illegal.
Right.
Nobody can remove your name from a will. That's
no
totally
one
illegal.
can, sir, nobody can remove your name from a will. You should definitely reach out to an attorney because the wishes of your father who made that will ought to come alive.
You need to get some proper legal advice
Yes.
and move forward.
Anything done would have been without consent.
That's illegal, okay?
Yes.
That's breaking the law. Welcome to the program. Hello?
Yes, hello?
Yes, welcome.
Yes, welcome here. My father passed away 2 years, right?
Right.
He didn't make no will. My brother said, attorney. Alright? With my mother. Then my brother wasn't for attorney. So is it
You're breaking up
Very
badly.
hard to hear him.
It's a little difficult to understand what you're saying, sir.
my father died, you didn't make it.
Daddy, right?
So my brother was a power attorney. And my brother wasn't for he already make it. So he has only a brother. He don't, so can avoid go to court for that.
Wow. I think you need to see an attorney and sit down one-on-one. But,
Yes,
but please, counsel.
I didn't quite understand
Yeah,
what
it
he's
was a
saying.
bit,
but if a
troubling.
person has made a will, to what I heard, if a person hasn't made a will and a power of attorney exists, the power of attorney dies upon the person's passing. So if they have not made a will, then regular law takes effect. And if you're saying somebody made a certain promise, that's what I think I heard, then there's something in law called promissory estoppel that can stop any, you have to file something in the probate section called a caveat, a document, to stop the estate from proceeding how it would be under letters of administration if no will has been made, and file an application in the High Court of Justice for promissory estoppel rights, which is equitable rights in the interest of fairness. This person made certain promises whilst they were alive. You acted to your detriment based on those promises or assurance that the property will belong to you. So it's arguable, but the person should definitely speak to an attorney. And I answered that, and I'm being very clear with not hearing clearly what they said, but gathering what they probably said, right?
Yeah. Good morning. What power is given as a tenant in a will? I'm not sure about the question. I don't know. I read it as it came.
Yeah, I'm not quite sure. The person could probably elaborate on it.
Okay. I would like to know if the executive of a property die, what will happen and her husband did not marry her as he has any rights? I'm just I'm trying to fix the English as
no
well.
problem. The only way that husband will have rights is if he was named as a beneficiary. Because you could have, I could appoint Harry as my executor, but Harry not in my will for no reason. I didn't name him as a beneficiary. I just want him to be responsible for giving out the estate how I desire. So because somebody is named as the executor doesn't mean that their spouse will get if the executor dies, or does not mean that the spouse fills the executor's shoes. Just to answer the previous call, like the previous caller asked, only the beneficiaries could determine if one of them wants to apply to be the executor who fill the shoes of the executor who passes away, or have an independent person.
Hi Zelisa, how long does a letter of administration take to process?
Right. Do you know?
That's another good question.
Do you know, that's a common question, because oftentimes members of the public will come from different attorneys' offices and say, my lawyer taking too long. But it's not really the lawyer, you know, sometimes things take a while. So once the application is filed, there's a case number given. I strongly urge members of the public who think it's taking long to send an email to the court or call the court or go to the Hall of Justice or San Fernando, wherever it's filed, and ask them for an update if that's why they're asking, if they find it's taking long.
I like that.
I
like that. You could go check on it.
Yeah, because I don't like people harassing me because I'm busy. So therefore, if somebody keeps asking me, if there's no update, we can't jump over the counter and do it. Otherwise, I would. Because I want it done just as much as the client.
Exactly.
So I usually just give the case number.
Nice.
But if everything is perfectly done in the application, which is probably unlikely because there's always a query that you might have to answer somewhere along the line and just oblige to what they're asking. I mean, within a year, probably, but it's not cast in stone, because if something isn't fine, you'll have to file an affidavit to fix it, and it could go over a year.
Okay.
I've had estates that take more than a year because things needed to be done along the way. So it's subject to the file and what's before you and the pace of the probate section.
Understood. So with that being said, let's go to these important messages. You are looking and listening to the program Conversations with Zelisa, in conversation with learned attorney at law Sajina Kadir. Let's go to these messages. When we return, we continue to take your calls and your messages. Stay with us.
On Saturday, 4th February, at the Center of Excellence in Macoya, feel the beat of soca and chutney on one stage.
Rub on the menu, we not here to pick and choose.
I love choca with Ravi B and Karma.
Drinking fire water, but this clay and powder.
Raymond Ramnarine and Tilly the Dan. Ding dong, ding dong. Sean Marshall, Irfan House, Rakesh Yankaran, the A-Team Band, Super Blue, Trinidad Killer, Temper, Iowa George, Nessa Preppy, Jadel, and much more. General tickets, $300. VIP, all-inclusive tickets, $800. For more info, call 757-8265. Coolers in before 10 p.m. No glass bottles. Brought to you by the Massive Tank Productions in collaboration with Kadir Media.
I love choca.
Welcome to the Antediluvian Nature Center of Life Extension and Health Recovery. Coming from the Garden of Eden, the Antediluvian Nature Center brings to you breakthrough medicines and anti-aging technologies for all ailments and diseases in the body, nutritional therapies, naturopathic treatments, as we create opportunities of hope and celebrate longevity. And remember, the healing is from God.
This is Full 100, an all-natural herbal dietary supplement formulated exclusively for men. Our proprietary blend was designed with one goal in mind: to improve your overall health, rejuvenating your vitality, energy, strength, and libido. Want to be at your peak performance in everything you do? Then get Full 100. Fast-acting, long-lasting, with no side effects.
Oh my God.
Trinity Service Center Company Limited, specializing in oil and fuel filters for both diesel and gasoline applications, automotive parts and accessories, making of key duplicates, servicing of both residential and commercial vehicles, which entails but is not limited to oil and filter change, underwash, engine wash, shock oil treatments, and much more. Fleet maintenance services. Come on down and check us out at LP number 602 Southern Main Road, St. Mary's Village, Karapichaima. Find us on Waze. Contact us at 352-0469 313 555 222 4098, or visit our Facebook page for more details. Open from Monday to Saturday, 7 a.m. to 5 p.m. and Sundays, 7 a.m. to 12 noon.
Welcome back to the program Conversations with Zelisa, in conversation with learned attorney at law Sajina Kadir. And welcome back, and we're going to go straight because we've got lots of questions. Can the lawyer explain what does the executor's responsibility when the person passes?
Sure.
Could you give us a little idea of what would be their duty?
So the executor, in a timely manner, usually within a year, should go to an attorney. If the person said, they prefer this attorney, fine, go to that attorney, or go to any attorney who does these type of matters or willing to assume conduct of the matter, and the attorney would firstly file a search to see if any will exists beyond what they are stating exists. And then the second stage, once it comes back stating that there's no will, the second stage will be to apply to file an application to probate the will.
Right.
And you'll have to get, like, you know, an inventory, what constitutes the estate stated in that will, and file certain documents in a bundle. And once that's filed off in the probate section, the executor will just wait, keep in touch with the attorney, and once it's granted, a grant of probate will be issued, and the executor will then have to stay with the attorney or go to another attorney of their choice, whatever it is. But if it's property, do a deed of assent. If it's property, to assent from the deceased person's name to those lawful beneficiaries.
Right.
Or take that grant of power, grant of probate to the bank to obtain the monies, and follow what the will says, distribute the monies in the apportionment that the person who passed away, who's called the testator, desires. So that executor caller or person who sent in the message is charged with a serious responsibility in law to give off the estate how the deceased person stated in the will, because if he does not do that, there are ramifications to him.
Okay. Pleasant morning, ladies. Lovely program. My question: in the case of allotting power of attorney executor to someone, what would be the situation if I am to give power of attorney executor to someone whom I trust for an underage person who has a medical condition that progresses as years go by? What would be the outcome?
I want to be so clear to the person who sent the message. Don't use the word executor in a power of attorney. A will appoints an executor, if it's male, or an executrix, if it's female, to carry out the wishes of the person who passed away. A power of attorney only has the grantor of the power of attorney and the attorney, who is the one who's going to carry out their business affairs, right? So the terms need to be understood.
Right.
And furthermore, the grantor of a power of attorney cannot give somebody to conduct their affairs if they are less than 18 years of age. So the person must be an adult.
Okay.
And additionally, if the person is a power of attorney, has nothing to do if a person is not well. You cannot make medical decisions in a power of attorney.
Well, you realize here in this situation,
people
the person
really have it mixed
age
up. Yes. And in a situation like that, if somebody is not well, the more appropriate route will be to file an application in the High Court of Justice to be appointed their guardian to act for on behalf of them. Only if a person has a physical disability that prevents them from going to, let's just say, the licensing office or CLICO or wherever to do a transaction, only then, as a matter of convenience, a power of attorney is done. But a power of attorney can't be done if somebody is infirmed, cannot make decisions for themselves, progressing in a way like that. It's not for that purpose.
Okay, good. Good morning, Zelisa. If someone was sick and they had a power of attorney and they got better after, can they change? Can the attorney answer that question? I think it's a good question.
Yes. So if there is no use for that power of attorney anymore, and you know the person is capable of taking that up and down, conducting the transactions or whatever, sure, the person could revoke that power of attorney. But leaving the power of attorney in existence means that the person could still act on your behalf.
Right.
So doing a revocation of a power of attorney is important if you want that power of attorney to not exist whilst you're alive. Remember, the power of attorney dies upon your death.
Yeah.
But if you want it to be null and void, you have to, just like you brought it into effect by filing it in the legal affairs, you have to do a document called a revocation of a power of attorney and file it in the legal affairs.
It's a legal process, and you need to get it done if you're not. Yeah.
That's right.
Hi, Zelisa. Can an executor change names on a will?
Can an executor change names? No. The executor, callers and viewers, are charged with the responsibility of giving out the estate how the deceased person state. They don't have any other power beside that. If they are also named as a beneficiary, they must also make sure they get what the deceased person wants them to get. But the executor, because the name sounds fancy, does not give them any power beyond that responsibility to give out the estate how it's supposed to be.
They are not allowed to change anything that you have on your will. That's illegal.
Exactly. That will be definitely have fraudulent consequences and ramifications under the criminal realms of the law.
Do you see cases as such?
We have, and once there's any issue of fraud alleged, the only way is to file a document, as I was saying, called a caveat, and apply to the High Court and file an application under the grounds of fraud. But in order to prove fraud, let's just say, for example, you even think the testator never signed that will, and you think a relative has a different will, and they believe that's the last will that the person signed. And in the High Court, you have to file an application for a forensic expert to come in and see if it's actually their signatures. So that forensic expert will take about 10 specimen signatures over the last 10 years and compare signatures to see if the one that is being alleged to be fraudulent is in fact fraudulent.
Okay.
So it's actually a process. So it's not uncommon where there are issues of fraud. And it can come from different angles. It can come from they're saying that the testator never signed the will. It can come saying that the executor tried to alter the will and name a different beneficiary. I mean, we see all kind of things, and it's arguable in law. It's the approach.
You really have to know and trust someone and know, do your little homework.
I can't emphasize that word you're using there repeatedly is exactly what callers should be and members of the public should note. You have to trust somebody. It has to be a well thought out decision to appoint somebody an executor of your will. Yeah, definitely.
I totally agree with that, because I mean, it's yours, and whatever you desire, your choices are, should be executed.
Yes.
Based on what
and
you
even
choose.
the power of attorney who you're granting it to, because sometimes, Zelisa, what we see is, let's just say I grant you a power of attorney and you're doing what you want, although we know you would never do that.
Yeah.
You know, what really happens is you start to mistrust somebody who you granted the power to, so you immediately have to revoke it. You know, the understanding the process is important, because some people don't know, and they will say, well, I'll just go to the bank and do my stuff, but the power still exists.
Yeah.
Nothing has stopped the person from acting.
Yeah.
And morally it will be wrong, but legally you have to cross all your T's and dot all your I's
I totally
and apply to revoke that power of attorney.
I totally agree. In conversation with learned attorney at law Sajina Kadir, and today she's speaking to us about wills, power of attorney, and if you may have any questions, any concerns, you can call us or you can send your WhatsApp messages 384-7142. Welcome to the program.
Hi, good morning.
Morning. Can I get volume, please? Yeah?
Yeah, I'd like to find out if someone who lives abroad can do a power of attorney to someone here without being here. The person who is doing it.
So I can explain.
Thank you.
You're welcome.
So for the person who called in there, you have to give, sorry.
Go ahead, yeah.
You have to give the attorney in Trinidad written instructions to proceed to draft it in the manner in which you like, whether it's a general attorney, power of attorney, or a specific power of attorney to do certain things specified in that power of attorney. But in order for it to be signed, remember, it must be duly executed. And if the person lives abroad, the attorney will have to send it abroad, and that person will have to sign it in front of a notary public. And like how I was explaining earlier, a commissioner of affidavits or justice of the peace have to authenticate that all the witnesses and everybody was present. The notary will have to do an affidavit as well, stating that they were present, they saw the person sign it, and then it's returned to Trinidad by FedEx or Global Post, whatever mailing system convenient, and then the attorney does the same thing here, which is register.
Excellent.
Yes, but it's doable.
Good morning and welcome. Hello.
Hello, good morning.
Good morning.
Hello, good morning.
Morning.
Good morning. Yes. Hello?
Yes, good morning and welcome.
Okay. All right. My mom was, hello?
The problem is you've got either your radio or television on, and that's why there's a delay. It's going to confuse you.
Sorry. Okay, all right. Sorry, let me lower it. I have on the TV.
That's why you should follow rules. Yes, quickly.
Take off or just lower it?
All right. So 384, hello?
Hi. Hello?
Yes, welcome.
Hi, good morning.
Morning.
Very interesting show, and I just wanted to find out if someone makes a will, it's a husband and wife, and they're separated, and the husband makes a will and he puts his 4 children in there, and the wife is left down, although they're separated. What happens?
Okay, that's a good question, and I think it's one that we could elaborate on. Can you listen off air, please? Thank you, darling. Thanks for looking at the show.
So
it's a good question.
If somebody makes a will, at the top of every will has, "This is my last will and testament," and revokes any former wills. So unless they revoke what they have already stated and executed in this will, the will still stands. Just like I was saying, when you do the power of attorney, if you no longer want the power of attorney to exist, you revoke it by an actual other document. Same with a will. The caller was asking, if you have a will that exists, whether the parties are divorced together, it's left to a housekeeper. If you want anything to change there, it goes to
we've
someone
got
else.
to take a break, but I would like you to elaborate on this when we return, because I think it's a question that applies to many people in many situations.
That's
in
correct.
terms of understanding what are my rights.
Yes.
Because here you have a couple, they are separated, they've got 4 children. The husband made a will which did not include the wife, only the 4 children.
Right.
Does she then have rights, or what rights does she have to say? Supposing she contributed towards their growth and development, and what, you know, I'm just saying.
I'll elaborate on the rights
I'd
of
like
the
you
family
to.
law act as well.
I'd love to do that. Let's go to these messages quickly. Stay with us.
Super quality supermarket. Best quality and great prices. Get your fresh fruits, vegetables and meats. It's a one-stop shop for the most affordable groceries, baby items, kitchen supplies, bathroom accessories, car care supplies, pet food, toys and lots more, all at Super Quality Supermarket. Wide aisles, fully air-conditioned and secured parking. 3 locations nationwide: Couva Car Park, Couva, 98 Endeavour Road, Chagonas, and 47 Tissue Drive, Trincity. Super Quality Supermarket.
The carnival season is upon us. Chutney Soca News, in collaboration with ZMB Communications Limited, is bringing the fun and excitement to you. We are throwing a studio party. Get ready for CSN Live. Live interviews, a live audience, live entertainment, and so much more. This and every Friday from 8 p.m. to 9 p.m. Broadcasting live on Facebook on Chutney Soca News TT, U97.5 FM, Multicultural Radio, and ZMB Communications. You can also look out for the rebroadcast on YouTube on ZMB Communications Limited and Chutney Soca News every Monday at 8 p.m.
My friends, this is Kieran Joseph Samaru. At a time when our country is going through so many challenges, economic challenges, crime, social disruption, a breakdown in infrastructure, and no light at the end of the tunnel, we must stand on a platform together and move forward. Join me on U97.5 FM for The People's Platform, a brand new, dynamic, powerful talk show that gives you, the people, the platform to speak about the issues important to you, the issues important to us. The People's Platform, every Monday to Friday from 6 a.m. to 9 a.m. on U97.5 FM. The People's Platform with Kieran Joseph Samaru, standing side by side with you.
Passage to Asia. Ultra all-inclusive. Carnival Kisses. Sunday, 5th February 2023. St. Andrews Golf Course. Mocha, Marabao. Get your tickets at Passage to Asia. Wings, Tuna Puna. Extra Food. Riverline, Price Plaza. MS Food City, Day. Westbees, Diego Martin. Richards, West Mall. Dave Sibalak Hardware, Penal. SC Persad Hardware, Marabella. Brand Tech, Londonville. Lazy Lizard, Rodney Road. Call 672-2701, 742-4309, 685-8697, and 465-7322. Passage to Asia. Carnival Kisses.
Welcome and welcome back to the program Conversations with Zelisa, in conversation with learned attorney at law Sajina Kadir. Welcome back.
Thank
now,
you.
before calls are coming and messages are coming, but I
Awesome,
want to
curious.
elaborate on this
Yes.
particular call that we got.
Right.
With regards, and I'm going to elaborate again, with regards to this husband and wife separated,
Yes.
they've got 4 children. So the husband made a will that everything goes to the 4 children. He
Right.
did not include the wife.
Right.
First of all, would that wife then, upon his death, her choice would be to contest the will?
Right. So I want to explain.
Please.
A will takes effect when a person passes away.
Right.
So if they are separated, she has the option of applying to the family court for matrimonial rights in the property, let's just say, for example, or even with regard to accounts.
While he's still alive.
Whilst he's alive.
Right.
So if a court makes an order with regard to matrimonial rights, and if that property that constitutes that order is stated in the will, the clause in the will becomes void, because whilst the persons are alive, the court has made an order. So if it is relative to the same property named in the will and it's different from what the testator wanted in the will, the court order will trump that clause.
Right.
However, if she does not pursue her matrimonial rights, the will takes effect upon the guy's passing. And if that's the case and the children are named, she can say, oh, well and good, my children are named as the beneficiary.
Right, they get it,
However,
fine.
if she believes that she has expended monies on this property and she'll be placed in a situation of great financial hardship, she could file a caveat in the probate section blocking processing that will in that probate section and file an application before a judge of the High Court of Justice to argue why she believes she has rights in it over and above what is stated under financial hardship grounds, which is allowed.
My humble suggestion to that lady or that person or whoever's in such a situation, get legal advice. Sit one-on-one and know how to move forward.
Definitely, it's important.
Yeah. My husband died, only his name is on the deed. He made no will. If I am having problems with bank giving my son a sign in my account, can I mention it in a will? I don't understand this question.
The person has spoken about 2 different things, but with regard to the deed, she will obviously have interest in that. Even in the accounts, she will have half the value of whatever is in the accounts, and the child or children will benefit the letters of administration.
Good morning to the panel. If I have my assets joint, do I still have to make a will?
Right. So if it's joint, there's a principle called rights of survivorship. So when one passes away, it automatically goes to the other. So with regard to the monies in an account, if you hold jointly with someone, there's no need to make a will with regard to those two assets. But I mean, you need to contemplate and make a will for those that you only have solely.
Okay. Good morning. Does a will override a joint tenancy deed of survivorship? I'm trying to read and edit at the same time. Or does the deed override? Because my uncle made a will for his property, but the deed is joint tenancy with 2 tenants alive. Still, please, I need help. Well, if you need help, you need to see. And
I definitely, because the terms are being used in a very layman manner, it will be highly irresponsible for me to comment. But I want to say, again, a will only takes effect when a person passes away. So it can't trump a deed. You can only trump a deed by doing a deed right now to change what is stated in the deed. So that person should definitely sit and have a proper discourse with an attorney.
Okay.
The terms are being mixed up.
Good morning. I have 2 children and want to leave the house for my daughter. However, can I will a bedroom in the house to my son? This is a good question, you know.
Yes, some persons leave wills where the upstairs portion goes to one child and the below portion goes to another. So you can be specific in a will how you would like your property given upon your demise. You can even say you would not like the property to be sold, things like that. A will is your wish upon your passing.
Well, I think people really need to understand that. It's your choice.
We have seen where persons leave 1 cent to somebody as a matter of an insult, but you could leave what you want in a will. It's your wish, it's your desire.
So let me ask.
Yes.
If you leave that 1 cent to that person, does that mean then that they do not have any right to contest?
Some persons may want to come under the grounds of financial hardship, as we were explaining, and file that caveat and go to the High Court and argue it. However, almost always when that is done, where a nominal figure is left for somebody, there's usually an estranged relationship where one spouse is aggrieved and it's a matter of a past situation and that sort of thing. And it exists. It exists globally.
Welcome to the program.
Hi, good morning.
Good morning.
Oh, okay, there is another question which I wanted to ask you. If there is a will and the executor fulfills the will and the probate comes and then the grand probate is completed and their job is finished, and then the will was advertised for the whole world to see, and then no claims was done on that will, and then the case comes up where there is someone who had a court case on that person, and they won that court case after the person died. What happens? They come and they blame the executor for not knowing that there was a existing case. What happens in that case?
I am not too sure I understand that question, and I feel I'll be responsible to just answer.
Yeah. My suggestion is you could send in a WhatsApp. I'll reread it.
I
will
could
say how we
though
could
that the
move forward.
executor would have done what he ought to have done, and if there was any grievance, the person in the public should have filed that caveat to block any action and pursue it in court. But this is me saying it very much on the surface because a lot of clarity needs to be asked.
Of course, in order to give the correct answer. All right. Good morning, very helpful program. My father died without making a will. Everything he has was in his name. I've taken care of him and my mother, both whom I live with. His debt, medical bills, everything I took care of. After his funeral, my mother took the eldest son who never lived with us and made a secret power of attorney. I saw published an application for administration in her name. I tried to stop it and employ an attorney. All I know, they were granted administration. This is so unfair. I got nothing from the large sum of money and I'm still living and taking care of my mother. He does check with her. My lawyer took my mother and did nothing.
Right. So I think what I understand it to be is, when his father passed away, the surviving spouse, the next of kin, will be the mother. Perhaps the mother did not want to take the up and down with regard to going by the attorney. So a power of attorney was done so that the other son is the one responsible for applying for letters of administration. Because he applied for letters of administration does not mean he does not have the responsibility to give it out to all the siblings equally. So if that person has been disadvantaged, then ideally a pre-action protocol letter should be sent to the person who has the power of attorney, the person whom the mother gave the power of attorney to ascertain the status of the letters of administration, if it has been granted, and to call upon that person to give an undertaking when they will oblige to what the law states in terms of giving giving him his portion.
Okay, rephrase. My question, does a deed override a will joint tenancy deed? Again, very confusing, but I don't know.
So if there is a joint tenancy deed, you can't make a will. You have to do a deed of severance so that upon your passing, your portion is left to whosoever you desire to. It's called a deed of severance. A will does not trump a deed that is made jointly in two persons.
I'm getting so many questions, but this will be the last one. I humbly apologize. We'll continue next week. But good day, Zelisa. I would like to know from the lawyer, who can be the witness to a will? Can a husband and wife be witness only to a will? Who is supposed to be the one to read the will?
Right. So it's the witnesses must both be over the age of 18 and not related to the beneficiary, because then there will always be issues of if the witnesses were mere witnesses of convenience, or it could have issues with regard to fraud. So the law says it must be two persons over the age of 18 and not related to the beneficiary.
Quickly. Morning, ladies. If I made a will to give my children XYZ when I die, can I change it if I find things are not going well? Yes, you can change your will.
Right. You can change your will when you're alive.
Live, of course.
Right. So the executor...
But is,
oh my goodness, Zelisa. Exactly that. You know, you take it out of my head. Because the way the person is asking, it almost sounds as if they're wondering if when they pass away something could be done, but you could only revoke a will when you're alive or change your will when you're alive.
We've got to wrap things up. Let me thank you. God bless you. I so enjoy sitting and chatting, but more importantly, getting messages out there
and
to
you see how many persons want to benefit from basic knowledge, right? And your program definitely presents a forum for members of the public to do that.
Thank you, darling. God bless you. We look forward to you joining us.
Same to you. Have a good day.
We've got to wrap things up. If you need her number, you could message me via WhatsApp 3847142. I'll forward her office number to you. And with that being said, thank you so much for choosing us. Please respect the law of the land. Be careful. Think before you act. Think before you speak. Take control of your life. Here's reminding you that with God, all things are possible. I am Zelisa Budusing Rupani. Thank you so much for choosing us. Have yourselves an awesome day.